You're watching the Legal Breakdown. So, Glenn, we've got some bad news here for two prominent Trump attorneys, John Eastman and Jeffrey Clark. So let's stick with John Eastman first. He was the architect for this scheme to have Mike Pence unilaterally anoint Donald Trump the winner of the 2020 election, which he lost. Now, a judge in California has recommended disbarment, so that now goes to the California Supreme Court to make the final decision. What's the timeline from here?
So I'm not sure how quickly the California Supreme Court will act on this, but I'll tell you, when I was reviewing the 128-page ruling that the California judge just issued, it's pretty devastating. Let me just read you one sentence. Judge, her name is Yvette Rowland, and she said Eastman's actions were carried out with deceit or dishonesty, and his plan to derail Democrat Joe Biden's election victory was unlawful and lacked any factual or legal support. Now, remember, disbarment might be the least of John Eastman's worries because he is also a criminal associate, a charged co-conspirator, a co-defendant in Donald Trump's Georgia State RICO prosecution, and he's also an unindicted co-conspirator in the federal prosecution in Washington, D.C. for Donald Trump trying to attempt to overturn the 2020 presidential election. So John Eastman has got a world of hurt coming down on him.
Now, what's the likelihood that the California Supreme Court accepts the lower court's recommendation?
I would bet the full dollar on it. You know, that's my betting limit, $1. I'm not a high roller. I'll put the full buck and then some on the California Supreme Court affirming this very thorough, very detailed ruling after there was a full trial on the merits. It was a bar counsel trial. It wasn't like a criminal trial proper in court. But, John Eastman could testify. He could call witnesses on his behalf. And I would be shocked if the California Supreme Court did not fully adopt and affirm the lower court judge's ruling.
And so then in terms of his ability to practice law, clearly he won't be able to practice law in California. But what about other states?
Usually the states have reciprocity, which means if one state bar disbars somebody, that will carry over to other state bars in the event Eastman is admitted to other state bars. There may be a procedure in place, but remember when, for example, another Donald Trump lawyer, Rudy Giuliani, was, I think, provisionally disbarred in New York. The first thing that happened was that the D.C. Bar Council picked it up and ran with it. And now Rudy, I think, is provisionally disbarred in D.C. as well. So listen, disbarred in one jurisdiction, you're going to end up not being able to practice law in all jurisdictions.
But the process isn't automatic, so they then have to go through their own process in each respective state. Is that right?
Yes and no. Each state bar council adopts its own procedures for disciplining their lawyers. Some of them, and they're different, and they're pretty wide-ranging. So some state bar council offices might just say, listen, we have full reciprocity. If he's been disbarred somewhere else, we use that as the basis to basically summarily disbar him without the need for an additional trial or disciplinary hearing. But again, every state bar, just like every court system in every state, they have their own rules and procedures.
Glenn, I want to get your response to there was a moment where the judge in the trial, when they found out that John Eastman would be placed on inactive status while we await the final decision from the California Supreme Court, that his attorney basically said, well, it's not fair that he's placed on inactive status because then he can't work to pay his bills while he defends himself in other ongoing cases. So what's your reaction to this complaint by Eastman and his attorneys that he can't make money practicing law while he awaits disbarment for abusing his law license?
My reaction is, let me look around for the world's tiniest violin to play for John Eastman. Because look, if you've been provisionally disbarred because you've engaged in unprofessional, unethical, and frankly, unlawful conduct, I just don't think it's a well-placed complaint that, but look, I'm also a criminal defendant down in Georgia, and geez, I need to come up with the money to pay my counsel somehow. Well, you know what? Work at Home Depot, flip burgers. I mean, you can still make money, but you've lost the ability to practice law, right? You're no longer in a position to represent clients, given the way you violated and abused your law license. So, yeah, I don't feel so bad for John Eastman.
Glenn, correct me if I'm wrong, but I believe the legal term for that is fuck around, find out. Is that correct?
He is definitely in the find out stage of that one. Yeah.
All right, so let's move over to Jeffrey Clark now. His disbarment trial is happening in D.C. What's the status of that?
Yeah, so he just hit the stand. He was just given the opportunity to testify in his disbarment trial, which is in progress in D.C., being conducted by the D.C. Bar Council. And, this couldn't happen to a nicer guy because there's a special place in hell for Jeffrey Clark. The reason I say that is he was a Department of Justice official, and what he did was join Donald Trump's criminal conspiracy in the run-up to January 6th. He weaponized, corrupted the Department of Justice, and tried to use it to assist Donald Trump in criminally and unconstitutionally overturning the results of a presidential election. Kind of the exact opposite of what a DOJ official should be doing. So here's what happened. He was given the opportunity to testify in his disbarment trial, and he really tried to avoid it, tried to use some procedural ducking and dodging, didn't work. So he ended up pleading the Fifth, invoking his Fifth Amendment right against self-incrimination over and over and over again. And let's be clear, lawyers know this, Brian, and I think the general public knows it as well. The only way you are permitted to plead the Fifth, to invoke your Fifth Amendment right against self-incrimination, is if your truthful testimony would tend to incriminate you. And let me just add on to that. I put lots of people in the grand jury over my 3 decades as a federal prosecutor, and a lot of them would plead the Fifth. Why? Well, because they were scared. They didn't want to testify. They didn't want to snitch. Or because maybe they were fiercely loyal to the defendant, the person I was investigating and intending to indict. So they would throw it up as a shield, and they would say, I plead the Fifth. Well, guess what? You can't plead the Fifth just because you're scared, and you can't plead the Fifth just because you don't want to incriminate somebody else. The law provides you can only plead the Fifth if your truthful testimony would incriminate you. So when somebody would throw up a bogus Fifth, we would walk across the street, we would have a hearing before the chief judge. The chief judge would determine if that person had a well-placed Fifth Amendment privilege against self-incrimination. Often they didn't. They were just scared, which I fully understand. I never beat up a witness, figuratively speaking, for being scared. But they had to overcome that, and they can't use the Fifth Amendment to just keep themselves from testifying. So what does that tell us? When Jeffrey Clark over and over and over again pled the Fifth, it's because his truthful testimony would have incriminated him.
And so we can draw a negative inference from that, correct?
You can in the court of public opinion, but let's be real clear. Interestingly, I just taught this topic to my criminal justice students at George Washington University. You can never use the invocation of somebody's Fifth Amendment privilege against them in a court of law. Why? Well, it would kind of defeat the purpose of the Fifth, right? You can't be compelled to incriminate yourself if you could then walk into court and say, well, ladies and gentlemen of the jury, he pled the Fifth, and y'all know what that means. That would actually be using his silence against him. Now, court of public opinion, you bet it's fair game for us to be talking about it.
Well, and take Donald Trump's words himself when he said that only criminals plead the Fifth. Now he has his own henchmen doing exactly that.
And interestingly, Brian, I love this aspect of his testimony. He was asked during the proceedings, he not only pled the Fifth, he also tried to plead all these other privileges. Many of them are bogus. He said, executive privilege and deliberative privilege and attorney-client privilege. That was a curious one. You know why? DOJ officials don't enter into attorney-client relationships with anybody, never mind the President of the United States. It's not what we do. We represent the interests of the American people, but we are prohibited. It's not ethical for us to enter into attorney-client relationships. So when he said the attorney-client privilege, you know what the examiner asked him? Wait a minute. Who were you representing? And he said, Donald Trump, the President of the United States. You know what? I would have said to him, hey, sport, that's not the way any of this works. And he knows that because he was a DOJ official. And what instantly came to mind when I read he tried to plead the attorney-client privilege because he claimed he represented Donald Trump, the President of the United States, it reminded me of what another DOJ official, Richard Donahue, testified to the January 6th House Select Committee about Jeffrey Clark, because Jeffrey Clark kept poking his nose into everything that was going on in the run-up to January 6th. He kept showing up at these Oval Office meetings, even though he had no business being there. And he was an environmental lawyer. He was a civil lawyer, didn't know anything about criminal law. And Richard Donahue turned to him when Jeffrey Clark kept inserting himself into this and said, hey, you're an environmental lawyer. You know what? If we have an oil spill, we'll call you. Otherwise, why don't you just go back to your office? But nevertheless, Jeffrey Clark joined Donald Trump's conspiracy, tried to weaponize and corrupt the Department of Justice in furtherance of that conspiracy, and that's why he is a co-defendant, criminal associate, co-conspirator of Donald Trump in the RICO prosecution in Georgia, and he's an unindicted co-conspirator in Donald Trump's federal prosecution in D.C.
And like you said, couldn't happen to a better guy. Glenn, do you think this will have any impact in terms of discouraging future lawyers from breaking the law on Donald Trump's behalf?
It certainly should. If any lawyers have even an ounce of ethics or they care at all about their law license, do not hitch your professional wagon to Donald Trump, because look at how many lawyers have suffered consequences because they were trying to do Donald Trump's dirty bidding, from Rudy Giuliani to Sidney Powell to Kenneth Chesbrough, now John Eastman, Jeffrey Clark, and who knows what the future holds in store for the Elena Habas and the Chris Kaises who represented Donald Trump in the New York civil fraud case. Of course, Donald Trump went down in flames in that case, and now he's being represented in the New York State prosecution for Trump's attempt to interfere in the 2016 election by a new batch of lawyers. So, you know, I can imagine those lawyers will also have trouble headed their way soon.
And let's finish off with this. What does this say more broadly about the state of the legal profession, at least in Donald Trump's orbit, that it's been allowed to get this far?
Yeah, I am not prepared to say the state of the legal profession is strong. I wish I could, but I think much of the legal profession has been exposed in the age of Trump, at least the lawyers who seem to forever be willing to flock to Donald Trump. I don't know. I can't imagine it's for the money, because Donald Trump so often stiffs his lawyers. Some people, I think, like proximity to power because they believe they can convert that into business in the future. But, you know, I'm reminded of a former colleague of mine, former federal prosecutor Evan Corcoran, who represented Donald Trump during the whole Mar-a-Lago affair. And what happened? Donald Trump urged Evan Corcoran to commit crimes for Donald Trump. The crime fraud exception applied. The attorney-client privilege evaporated because of it, and Evan Corcoran had to go into the federal grand jury, frankly, where he and I used to go present cases and seek indictments, and he had to testify about the crimes of his client, Donald Trump. Why people would hitch their wagon, why lawyers would hitch their wagon to Donald Trump, it's beyond me.
Yeah, and of course, his current lawyers have the advantage, so to speak, of watching what will eventually happen to them in real time. So, but, you know, is that going to stop them from representing him? Probably not. With that said, we'll obviously stay on top of any disbarment proceedings as they continue to move forward, as well as the rest of the prosecutions that Trump is contending with as we head into this upcoming Manhattan trial starting on April 15th. So for those watching right now, if you want to follow along, please subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.